Negligence is the breach of a legal duty to act reasonably that is direct or proximate cause of injury to another. In non-legal language, negligence is carelessness that causes harm. Assume the hole in the rug had been there for 2 weeks. Failure to fix the hole is carelessness. The restaurant could be anticipate that someone would be injured by it. As a result, the restaurant will be liable for the customer's injury. The law requires that people and businesses act reasonably in attempting to prevent injuries. When someone acts unreasonably or carelessly, that person is negligent. A reasonable restaurant employee seeing a hotel employee who had been alerted to hot water problems in the hotel would investigate and correct the problem. Failure to make them necessary repairs in these examples constitutes negligence. If the cause of a hotel guest injury was the carelessness of an employee, the hotel will be liable to the guest. Managers and employees of restaurants and hotels should strive to act reasonably in the way they perform their duties in order to avoid liability for negligence. Elements of a negligence case. A plaintiff suing in negligence must prove four elements. Failure to prove any one of them is fatal to plaintiff's case. The four elements are: first, the existence of a duty to act reasonably owed by the defendant to the plaintiff. Second, a breach of that duty. Third, injury to plaintiff. Fourth, proximate cause. This last element means the breach of duty must be the direct cause of the injury and no intervening cause exists. Existence of a duty to act reasonably. We do not owe to everyone the duty reasonably. We owe the duty to those people who would forcibly be injured by our actions. A restaurant can foresee that if the leg of a chair is broken, a patron will sit on the chair and fall. Therefore, the restaurant owes a duty to its guests to repair the chair. If the restaurant or hotel cannot foresee a particular type of injury, it does not owe a duty to protect patrons against that injury even though someone is in fact injured. Injury. To win a lawsuit, a plaintiff must have suffered injury as a result of defendant's breach of duty. The injury might be bodily harm. The legal term for this is personal injury, such as broken arm or head injury. The injury could also be property damage such as a dented car or emotional or monetary loss. Summary of the elements of negligence. Remember, before a hotel or restaurant will be liable to a plaintiff for negligence, all four elements must present. First, the existence of duty. Second, breach of that duty. Third, proximate cause. And fourth, injury. If any element is missing, the hotel or restaurant is not liable. Legal status of plaintiff. The duty of care owed by a hotel or restaurant for the safety of its patrons depends in many states on the legal status of the person injured. He may be an invitee, a licensee, or a trespasser. Trespasser. The greatest degree of care is owed to an invitee, the next to a licensee, and the least amount to a trespasser. Duty owed to invitees. In hospitality, an invitee is someone who comes to an establishment for the purpose for which the business is open to public, or for a purpose directly or indirectly connected with that business. For a hotel, invitees include guests and visitors of guests. For a restaurant, diners are invitees. For a bar, patrons are invitees. For all three, employees are invitees, as is a delivery person delivering some item necessary for the business. The hotel or restaurant owes a duty to its invitees to reasonably inspect the premises for dangerous conditions and to exercise reasonable care to eliminate them. Duty owed to licensees. A licensee is someone who has been given permission by the owner or occupier of a facility to enter or remain on the property, but his presence does not further defendant's business. An example of license is a witness or front desk clerk who, on a day off, goes to the place of employment to pick up a paycheck at the time the employee is not furthering the employer's business interest but nonetheless is on the premises with the employer's consent. Similarly, a former employee who enters the premises for purposes of meeting with a current employee is a licensee. Duty owed trespasser. The least duty owed to a trespasser, a person who enters a place without permission of a owner or occupier. If an employee who has been fired and ordered not to return to the hotel nonetheless enters the premises, he is a trespasser. Someone who enters a restaurant after it is closed for the night without the owner's permission is a trespasser. A landowner or a possessor does not owe a duty to safeguard a trespasser from injury due to condition on the land. Minority position. Some states have abolished the distinction between licensee, invitees, and trespasser, and the duties owed to each. Instead, in those states, the occupier of land owes a duty of care to all three. However, the standard of reasonable care may vary with the circumstances of the visitor's entry on the premises. No special duty owed to others. What about people who do not qualify as invitee, licensee, or trespasser? In most cases, no duty is owed. In the following case, the innkeeper had no relationship with the injured party and therefore owed no duty of care. And lastly, no duty owed on property not owned or maintained by the hospitality facility. A hotel or restaurant is generally not liable for injuries that occur to patron on property not owned by or maintained by it. Even if the property is near the hotel or restaurant's facility, thus a restaurant was not liable to diners who were assaulted in the parking lot located behind the restaurant but not owned or maintained by it. The court specifically noted that the restaurant did not pave, snowplow, clear, or patrol the area where the assault occurred.